Good afternoon, everyone. Welcome to our panel, which we call Data Protection as a Privilege, Digitalization, Vulnerability, and Data Subject Rights. It's organized by the SPECTRE research project. I myself am the moderator today, and I am a PhD student in Media and Communication Sciences at the Free University of Brussels. And in our project, in our research project, we've been researching for almost 4 years by now data processing in and about public space in the city, in the smart city, which I would say takes place for many good purposes, but obviously there's also many risks to that kind of data processing. Risks not least to the fundamental rights to privacy and data protection of the citizens in the city. And my own interest, or our interest here, is how to effectively involve people, how effectively involve people in assessing risks and benefits of data processing operations, to understand how they feel and how they perceive what is acceptable for them. And what is not acceptable, of course. So a core challenge for our work and our research is clearly the knowledge and communication, or the translation of knowledge. How can knowledge of complex technical systems and complex legal provisions be translated between experts, between organizations, and obviously also, especially to non-experts as the citizens. The question is, if we want to consider together what a risk to a right is, how can we do that with normal people if it's already difficult for us to understand what that legal concept means? And since it is clearly not easy for any non-expert to understand and to act upon these complex concepts, there's some groups in society that certainly have it more difficult, or for whom it might be even almost impossible to participate in these discussions. For example, if you're not able to read or to write, if you're not able to speak a language in which a privacy notice is composed, or if you're simply not able to make an email account. For our research, we've been trying out different methods in this regard, how we can involve people, how we can talk to people across different disciplines and across different groups in society. And just as an example, we've been doing a couple of workshops or data walks in Brussels and other cities in Belgium, which we conceived. So basically a workshop is you walk around the city, you look at cameras and other sensors, and you discuss with people how they feel what's happening, that they're being filmed, for example, that their personal data is used for this or that purpose. And we conceived of this methodology as something that is very open, very low threshold, with almost no barrier for anyone to participate, because you don't need to read or write. You can just come and discuss with experts, so with us researchers on an eye level, what you feel about what's happening around you. But we still, with this methodology, we reached a very limited amount of people, a very limited group of well, let's say the usual suspects. So that leads me to today. Today we want to discuss why it seems that data protection rights, which are seemingly promising tools to empower individuals and counter some power asymmetries, why they seem to be a privilege that is restricted to a quite small group of experts. So in this panel we want to consider whether data protection law, and especially the data subject rights, can help vulnerable individuals to improve their position in society and to avoid exploitation, whether and how this has happened in practice already. And last but not least, very importantly as well, the underlying question if what a vulnerable data subject is, and if this whole framework of vulnerability is actually the right one to approach for us, certainly as researchers, but also in practice to approach these issues. And for this, I'm very happy to introduce Nele Roekens from Belgium, UNIA, the National Human Rights institution here. She's going to talk about risks of algorithmic discrimination. Then Jit Eidinalp, working for the European Sex Workers' Rights Alliance, talking about the importance of data protection and data in their lives and in their work. Dr. Paoli Pieri, who is the Director of Research at Democratic Society in Berlin. Well, in Berlin, in Europe. And James Farah from Worker Info Exchange in the UK, who's going to talk to us about Uber drivers and how they help them to realize, exercise their rights. So I think we would start with Nele, if that's okay. Cool. Thank you.
So, thank you for the kind introduction, and thank you all for choosing this panel. It's an honor to kick off. So I'll start by quickly presenting UNIA. Jonas already said this is the Belgian National Human Rights Institution. This is a UN requirement for countries. It is also an equality body. This is a European requirement for member states. And so we are the Belgian public interfederal institution that combats discrimination and promotes equality. That digitization and AI with its specific characteristics like the opacity, the lack of transparency, complexity, dependency on data, etc., can adversely affect fundamental rights is widely acknowledged. And you probably have all heard about scandals like Clearview AI, Facebook discriminatory housing advertisements, or the Amazon recruitment tool that was discriminatory for women. So at both European networks, we actually have identified digitization and AI as a priority when tackling human rights abuse and non-discrimination. And you might have heard yesterday our Danish colleagues talking about the fundamental rights impact assessments. But although I would love to discuss thoroughly on freedom of thought, manipulation, the effects on democracy and rule of law of digitization, today we will solely focus on non-discrimination and equality. And you might wonder why non-discrimination receives particular attention in this technology and fundamental rights debate. Well, simply put, this is quite easy. Our society is unjust, unfair at the moment, and AI, which are often predictive processes based mostly on historic data, tend to not only copy these existing inequalities, but reinforce them. So I can all recommend you to take a look at this report made by Equinet on the role of equality bodies in this context. But today I will talk a little bit more also about the barriers we face. At UNIA we have 3 main activities, including case handling. And we do have received some notifications regarding algorithmic discrimination or other digitization decisions that negatively affected civilians, but these are extremely rare. And considering we receive about 8,000 notifications a year, we feel that civilians are often not aware that potential discriminatory decision has been made or personal data has been processed. So this is the first bullet point on the slide, the lack of transparency. But even if we would know that personal data was processed or a decision was fully automated, and which variables were used and which target variables were used, it would remain extremely difficult, and even for experts or professionals, to really understand what is at stake and if a certain decision is in violation of fundamental rights. And I'm not even talking about a black box. So digital literacy poses a major barrier in the context of vulnerability. And another barrier is that equality law does not always easily apply to digitization, to these new technologies, actually. Equality law dates back decennia, and there are some major conceptual misfits in the context of discrimination. So discrimination usually occurs when someone is treated differently based on a protected criterion, and this has a negative impact. So in the AI context, first of all, we wonder how to compose the comparator group, but also more interesting in this discussion is that traditional anti-discrimination law relates to discrimination on basis of one protected criterion. And in an automated context, taking into account the lack of transparency, but also the high level of differentiation, it proves extremely difficult to establish on what protected ground a certain credit scoring, recruitment decision, identification was made. Is a certain candidate being rejected because she is female, or is it because she wears a headscarf? Is it because she is a woman of color or has a disability? Or is it only the combination of these different criteria that led to a certain decision? I'll be honest, these kind of decisions are currently very hard to challenge from an equality law point of view, and considering the risks of AI in perpetuating existing inequalities on the one hand, and on the other hand, the growing acceptance that racism and discrimination are structurally embedded in our society, this is extremely worrisome. And a possible solution to this to properly protect all vulnerable groups could be an intersectionality approach. But let me quickly check by show of hands who has already heard of the concept of intersectionality. Okay, I see that the majority has already heard about it, and my co-panelists will also dive deeper in the concept. You find some of the main elements that all thinkers tend to agree on the slides. But important to note here is that this allows for a broader approach that could provide an answer when decisions are the result of several protected grounds interacting with each other at the same time in such a way that they are inseparable, which will very often occur in a digitized context. But important to note is that this has not been legally accepted, nor by the European Court of Justice, nor in national case law. And before I will elaborate on the role of privacy in privacy law in equality law cases, I will briefly run you through some key concepts. A first challenge is that equality law at the moment works on the basis of a closed, exhaustive list of protected criteria that does not always mirror the societal needs of vulnerable persons. And secondly, this is quite an interesting feature. Usually in our society, there is some kind of fault required to establish an infringement. And as a society, we deem that reasonable. But in equality law, this is not necessary. There is no intention required to establish a discrimination, even with the best of intentions. Some of you might already have heard of the French Parcours Up case. This was actually an algorithmic platform that was introduced by the French government to select and assign students in an equitable way. Our French colleagues successfully contested the system, and they actually on grounds of data protection law and standards. And lastly, to address difficulties in proving discrimination for vulnerable groups, a shift in the burden of proof was introduced in equality law. This means that when a claimant can provide some facts from which discrimination may be presumed, it's actually to the defendant to prove that no discrimination occurred. And even more interesting in this context is equal pay litigation, which states that when a system completely lacks transparency, it is for the defendant to prove that no discrimination occurred. This is a case law of the European Court of Justice. But what about the essence, so data protection law? In equality law, there are no specific rights foreseen to obtain certain information, and nor in the AI Act, you are all well aware that there are currently no direct rights for individuals foreseen in the Act. So actually the GDPR and the direct rights listed in Article 12 to 22 could actually be invoked to gather the necessary elements to reverse this burden of proof. I am not a data protection law specialist, but I've been told that the meaning is debated, and like in every branch of law, it has a specific scope of application, and there are a lot of exceptions. But at the moment, we feel as equality law bodies that data protection law and privacy law can be useful, as is also shown in the Dutch Siri case, where the legal tool used by the government to combat fraud that you're probably all aware of, that was also in violation with Article 8 of the European Convention of Human Rights. So let me conclude with some next steps we identify. First of all, we think it's very important to continue the debate on vulnerability, and this with meaningful participation with all those concerned, like Jonas' project is attempting. To ensure that existing tools or new tools can provide for effective protection for all vulnerable groups, there is need for some amendments, and this could include including intersectional discrimination in equality law. Secondly, we should thoroughly invest in education, in accessible education. And although education does not amount to protection, it does play a crucial role. Individuals and vulnerable groups should understand their rights, but should not bear the responsibility to ensure protection. Therefore, we should ensure responsibility for legislators, policymakers, and industry by, for example, introducing the reversal in the burden of proof, mandatory registers, information requirements, and so on. And let me conclude by saying that when a tool is not fit for a certain purpose, it should not be used at all. Technology will and cannot fix all the underlying societal problems we are facing, and we should also discuss how to handle them. So I thank you all for your attention and give the word back to Jonas.
Of course. Hello. Yes, working. Hi everyone, thank you so much for being here, and thank you Jonas for organizing this very important panel. I'm here today to talk to you about digitalization, thank you. Digitalization and its impact on sex workers, both positive and negative. I will then give a quick summary of factors that make sex workers vulnerable to digitalization and present some examples of how sex workers are trying to counter the threats in order to protect their privacy. So first of all, I should introduce the organization a bit. So we are European Sex Workers' Rights Alliance, and we are a network organization with more than 100 member national organizations in 30 countries in Europe and Central Asia. And we focus on areas such as sex workers' access to health, sex workers' access to justice, labor and social protection, and as well as digital rights, sex workers' digital rights. So impact of digitalization. So it's a transformative process, of course, for everyone and for the society, and the case continues for the sex workers' own lives as well. The main impact digitalization brings in the context of sex work is the shift from traditional workplaces to internet-mediated indoor sex work. Traditional workplaces such as, for example, brothels, sex clubs, strip clubs, and so on, or streets. And we define sex work as provision of adult sexual services in exchange of material goods, by the way. This is very important. So this shift from traditional workplaces to online workplaces for sex workers enables sex workers to generate income in a variety of ways. For example, through camming or adult content creation, for example, through OnlyFans page, or online advertising of in-person services. And it also increases sex workers' ability to screen clients, to decide which client is safe to see and which client is not safe to see. They have certain tools to do this kind of checks. So, and also digitalization brings sex workers better access to health and safety information online as well. So I wish we could say everything is flowers and pink clouds, but of course it brings also lots of risks for sex workers. And one of the biggest risks it brings is its harmful impact on privacy and data protection. Sex workers are extremely stigmatized community because of the work they are doing. But also in many national contexts, sex work is criminalized in one way or another. So this privacy is important for every one of us. However, the stigma and criminalization makes sex workers extremely vulnerable to, privacy violations and what it can bring, basically. Because for sex workers, privacy is a matter of life and death, literally. So sex workers develop many strategies to keep their real identity a secret. And they build certain, barriers. And however, these protective barriers are being taken down every day, and data collection from sex workers and other communities at risk increased exponentially, putting sex workers' health and safety in danger due to regularly occurring data leaks. Sex workers experience, due to these data leaks, blackmails and extortion from other individuals, including the police, who manage to acquire sensitive data about them and use this data to demand free sex or extort money. They do such things by, of course, weaponizing the digital technologies we have, and especially surveillance technologies such as CCTV cameras, predictive policing, facial recognition technologies. But even cell phones of sex workers are being used against them to gather data from their browser history or Google Translate history to then prove that they are sex workers and then use this information against them. The online adult sexual advertisement platforms, this is the platforms where sex workers advertise their services, they collect passport ID copies from sex workers if they want to be registered on their platform. And they keep these passport ID copies in their databases in horrible conditions probably, because data leaks happen so often, and so much of this data then falls into the hands of other individuals. And although such threat impacts all sex workers, even in the case of, in this case, some sex workers are better protected due to being more privileged than some of their other colleagues. All these risks, increase exponentially for migrant sex workers, for example, especially if they are undocumented. They cannot go to the police or exercise their data protection rights due to fear of being outed or being deported. They also may not have the language skills, which was mentioned, to exercise data protection rights, right? You have to understand first the law and everything. While racialized sex workers are more likely to face discrimination by AI tools and certain AI practices, sex workers in poverty cannot, for example, invest in privacy-enhancing tools. And lack of digital literacy also prevents sex workers from keeping themselves safe. These are two quotes from sex workers in two different countries. The first one is from sex workers in Russia, which demonstrates how sex workers' online privacy and safety has an impact also offline. And it also shows that how sex workers cannot even go to the police when they are a victim of blackmail or extortion. They are made vulnerable by the stigma and the laws that criminalize sex workers. The second one, I hope you can see them. Tell me if you can't, and I can read them for you. The second one is from UTSOPI, Sex Workers' Rights Organization here in Belgium, where they talk about how newer technologies such as AI systems are used against migrant sex workers by private companies and European institutions alike. So how sex workers counter these threats then? So unfortunately, many of the strategies sex workers developed to protect themselves are band-aids. Thank you. Many of our national members are organizing skill-sharing workshops, for example, where they share their strategies and tools that keep them safe to enhance their privacy, such as how to use VPN, for example, or how to avoid CCTV cameras. They, for example, map CCTV cameras in the city so that sex workers who work in the street, don't go to those streets. Or simply how to safely, surf online. They exchange this kind of information. Sex workers' rights organizations also produce many publications on digital security, which are translated in several languages to make them more accessible, especially for migrant sex workers. Some of our members provide support for sex workers, for them to have some form of control over their data by giving information on the right to be forgotten, for example, on GDPR, and to have some, to exercise their rights in also national contexts. Lastly, sex workers' rights organizations are constantly reacting to laws and policies drafted with absolutely zero consideration of sex workers and other marginalized communities. health and safety. A recent example for this was the DSA amendment, I don't know if you followed, 24B, which proposed to bring mandatory cell phone registration for all pornographic content creators, which we advocated against, and it was not accepted. So this is just some of the publications, examples, and websites that sex workers, produced about digital security. So band-aids are good. However, as ESWA, we always invite everyone to try to see the bigger picture and the real way to make meaningful changes in our society to protect the most vulnerable. And one of these is obviously we need, more structural changes. We say no to solid, tech solutions for complex societal issues. So we need, in the context of sex work, we need full decriminalization of sex work, and so that sex workers can exercise their data rights, so that they can go to police if they need to. And the other thing is that, like I said, intersectionality, it was mentioned, which is so true. Many sex workers are migrants, and many of them are undocumented migrants. So we can't expect them to exercise any kind of control over their data if we also don't set some kind of firewalls for them to, safely go to police without the fear of being deported. And let me just check. And yeah, sex workers' rights organizations, digital literacy is important, obviously, and sex workers' rights organizations are the institutions who can do this properly. So we also need funding for their already ongoing good practices. And finally, the laws and policies that govern sex work and sex workers have to include sex workers' voices. So we don't keep seeing this policies and laws being drafted without sex workers' input, so that it impacts us. I think that's it for me. Thank you for listening.
Yeah, I'm not sure which one I'm going to use. This one is okay? Can I use this one? Yeah, I think so. So thanks for inviting us, Jonas, and thanks everyone for being here to attend this panel. So I'm going to share some work that we've done at Democratic Society on digital rights, including citizens, and trying to collect citizens' voice to understand what digital rights mean and what sense, what meaning they can make from that. So we learn from the lived experience, as we say, of digitalization. And I'm going to share, if we have the time, some reflections at the end. Otherwise, I think there's going to be time in the Q&A, I hope. So what I want to do just very briefly before I go into the topic, introducing the organization that I'm representing. So I'm here on behalf of Democratic Society, and we are an NGO that work across Europe to advance democratic principles and practice through projects. But we also do a lot of research to understand, for instance, in this case, the impact of digitalization on democracy and the public space, and the quality of the public space and the public debate. We touch, when it comes to digitalization and democracy, on different topics, but I would say what is the angle for us, that is our expertise, of course, and unique thing that we bring to the conversation, is the public engagement, the public oversight, and expertise on governance, which are very important issues that have been mentioned, of course, at this conference as well. So the kind of reflections and findings that I'm going to share are very much coming from this one project, really important piece of work that we did, which was called Citizens' Voice for Digital Rights, which was funded by the Cities Coalition for Digital Rights. I don't know if people are aware, which is a peer-to-peer support network made by cities that are trying to actually take a different approach to the old debates of and discourses around smart cities, and are talking about advancing rights-based digitalization strategies. The project was carried out in 4 cities where we engaged citizens in conversations around their lived experience of digitalization, with the aim to design with them path for advocating for their own digital rights and for their communities' digital rights. The focus of the work, which I think is also very relevant to the project, the SPECTRE project, is the city. And we wanted to work with cities because for us was that really important, is a really important space where actually digitalization as a concept and as a process becomes really material. As at the city level, people, everybody, every one of us, you were talking about walking through the streets to see the CCTV cameras, is the space where we actually can experience and materialize digital processes that might seem a little bit more abstract. And I think we thought it was also really important because of data and digitalization in cities, because of course of the smart cities agenda, have become very much another element of infrastructure that is very rarely talked about. And what is really for us was really wrong in a lot of the debates around smart cities is that these conversations are really not including the human element in them. So there's a lot of talks about smart cities as being about the technology, being about the digitalization, being about the data and the use of the data, and we actually wanted to bring the voice of the people in that conversation back in that equation. That was really important for us. I'm going to touch on these 4 points. I think the fourth one is going to be maybe the most relevant for this panel, but these are some of the things that we learned. Generally, I said before, democratic society works on citizen engagement more broadly, but when it comes to citizen engagement in digitalization processes or on matters and topics of technology or data, for instance, we think there's a lot more to be done compared to many other fields in order to ensure proper public oversight and proper public engagement and participation. Also because, for instance, a lot of the conversations and debates on this, when it comes to talk about the role of citizens in those spaces, are very much posed in the negative frames because they talk about lack of knowledge, lack of understanding, lack of interest. Citizens, people don't bother about these things. But there's also the negative frames of trying to protect from the harm, and so react. They're very much a reactive debates when it comes to digital rights and the role of citizens and the citizens' voice in that space. The second thing that we've been also touching already on the panel, so I'm not going to go too deep on this one, is for us that the opportunity to participate is not enough, but citizens need the confidence, the information and the confidence. And the confidence is exactly that digital literacy or critical digital literacy skills that are a right in itself, but are also the way in which people can exercise their rights. They can understand what rights they have, when these rights are infringed, where to turn if these are infringed. These are all things that need to be built, and we can't give it for granted. The third thing that we learned, and of course because we were working a lot with cities, is actually how important cities are. And maybe something that is not often realized is that when it comes to introduce data protection regulation, when it comes to introduce digitalization strategy or make key decisions that will impact on data protection and data collection, citizens officials themselves will need a much better understanding and support. What happens a lot in smart cities, again, not very much a story that is told in that space, is that big cities get properly built ad hoc infrastructure and digitalization solutions. Small cities usually get a copy of that. They don't get anything new or anything bespoke. They just get the same functionalities that the company has developed for other cities. So again, what does it say about data being contextual, data being cultural, and different cities and citizens having a voice in deciding what digitalization processes should be introduced in the city? This point, I think, is the really important one for us, which came a lot as we were trying to understand from the voice of citizens what digital rights meant to them and what vulnerability meant in that space. And for us, it's actually a useful framework, which I understand, is used, of course, increasingly more used when it comes to data protection, conversation, and data subject rights. But we also thought it is a contested one. So people are not vulnerable by default, or we can't or shouldn't assume who is vulnerable, who is not. And there is, in fact, a dichotomy between vulnerability as a personal or particular situation or condition and vulnerability being a universal condition. That said, without of course forgetting and very much acknowledging that there are institutional barriers and there are institutional conditions that make certain groups more vulnerable than others. But we thought it was really important, and the citizens could define when and how they were made vulnerable, in which conditions. Vulnerability is sometimes the point of the starting point, but is also the end point of a data breach of privacy regulation that are not followed and not respected. And one example exactly in conversation around privacy that came across really strongly is that people felt it was a problem of understanding in the law, but it's also a problem of not having alternatives. So again, we are made vulnerable in certain circumstances, and that came out really strongly, and I think it's important maybe for this panel to also consider that dichotomy within vulnerability conversations. And very quickly, 2 more minutes, some reflections, some general reflections that we wanted to bring to this group and to this panel that we've learned again from the project. Because of course of the focus of work that we've done, but cities were for us emerged from us in that piece of work really strongly as a key actor when it comes to also questions of digital sovereignty. I know they have less powers, of course, than the state, and they have less power than the EU, for instance, when it comes to law enforcement. But actually, they have an important role as sites of experimentation. They are very close to different groups, and when it comes to listen and engage people in deciding and designing also policies and laws regarding digitalization and data protection, cities are very well placed to do that, with all the limitations. What was also interesting that we learned by talking to people is, and again, I think this speaks a lot to the vulnerability question, citizens are vulnerable in certain circumstances. They want to be seen as experts in other circumstances that are experts of their lived experience of digitalization, how it affects them in a specific context. When we were talking to the people of Tirana, that is an expertise that they bring and that is unique to them. So it's about recognizing the different roles that they can play. And it's interesting to see this really kind of emerging trends also in participatory AI, which are very much looking at the role of citizens as co-creators of AI solutions, innovators, and makers as well. So again, trying to go a little bit beyond the usual maybe picture of who is the citizens that we're talking about. And finally, this idea that when it comes to engage and listen to the voice of those who, especially the most marginalized group that will be affected by a decision or a policy-making exercise, we need to think about the whole cycle, and we need to engage them as soon as possible in the actual design of the technology, in the decision regarding a specific policy or a specific strategy, until to the end of, like, developing a strategy and being involved in the delivering of the strategy itself. So this is very much for us like the whole cycle, the whole digitalization cycle approach that is at the moment very much missing in this space. And I'm finishing here. Thank you for listening.
Well, I'll try. It's a very tough act to follow, so 3 excellent presentations. And I've got no PowerPoint slides, which I kind of regret now. But I really appreciate Paolo's discussion about smart cities, because maybe the story I'd like to talk about is the journey from vulnerability to strength. And my personal journey in that was started with an assault. And years later, when I got my data from Uber, I was able to map it. I know you can't see it, but I'm happy to show it to you afterwards. So there's every trip I ever did for Uber for 10 years, for 2 years, 10 years, God knows, 2 years in London. And yeah, so you can look at that. But I was able to find that assault on the map, and I was able to zoom in on it, and I could see, the slow speed of red. It's like a blood mark, really, of where I was detained on the street for a couple of hours waiting for the police and so on. And it brought home to me how important data is. It's not just numbers. It isn't money. it's experience, it's our work experience at work, and how important it is for people to be able to have access to that, to explore it, and to think about how they worked in these cities. So my name is James Farr. I'm Director of Work Info Exchange, and my evening job is I'm Secretary General of the App Drivers and Couriers Union, all based in the United Kingdom. And I was part of a worker rights claim against Uber that was successfully heard at the Supreme Court last year in the UK. We were confirmed as workers. But the case rattles on because now we have to debate for 4 weeks in court next month about when we are workers. So it's a never-ending case. So litigation isn't often a very easy thing for vulnerable workers to get their rights. But during that case, the aha moment for me was Uber came to and my fellow claimant, they were sort of smearing us by saying, look, we have all the data on these drivers. In my case, there was a reference week in July 2015 where I only accepted half the work that they offered me. And they're saying, well, this guy is only accepting half the work we offer him. That's why he's now earning less than minimum wage. I mean, he could be at home in bed, you know, hitting no, 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 cancel, cancel, cancel. But we shouldn't give him he shouldn't be entitled to minimum wage. Luckily, I found another document. And another document that Uber had was suggested in the onboarding documents that if you work between 1.4 and if you work between 40 and 60 hours a week, you should complete between 1.4 and 1.6 jobs per hour. But in my 91-hour reference week, I was doing 1.59 jobs per hour. So in other words, I was on the upper end of productivity at 91 hours that they expected for 40 to 60. And they're telling the court I didn't deserve minimum wage for that. And they told Parliament, they gave this evidence in Parliament. And they released a podcast saying that they were appealing our case on ethical grounds because we were cancelling work and they thought we didn't deserve minimum wage. And it was an ethical principle for them. In terms of vulnerability, I think it's an unfortunate topic in a way because, you know, what trade unions do, what we have to do is build strength. We have to build strength against this platform. And we have to project that strength. And that's very difficult to do because you have to start somewhere. And we started nowhere with nothing. 2 people, we used to pass around a saucepan in a room to collect enough money to hire the room so we could meet. Yassine, my colleague, would hold union meetings in an open park because we had no money. And we've grown that union now to 6,000 subscribing members. But in our first demonstration, you know, it was suggested to us that we should wear the anonymous masks. Remember Anonymous at the time? And we took a decision, no, we could never do that because we would be projecting weakness and fear from the beginning, that people should be afraid to stand up for their worker rights. Now, in terms of vulnerabilities to the workforce, what are they? It's 94% minority group in London. 74% are coming from the most deprived communities in London, according to the statistics. The vulnerability, obviously, is the asymmetry in the relationship you have with a platform. With this group, the majority religion is Islam, Muslim, Pakistani, Bengali, Somali drivers. And so Islamophobia and racism is an issue. We did a survey and found that more than 50% of drivers have been assaulted on the job and 84% have experienced some kind of hate crime on the job. And when these issues are raised with either the operator, as in my case I was assaulted, not because I'm a Muslim, I'm not, but I was just assaulted for any old reason, but the police, you know, the operator didn't want to cooperate with the police because they didn't want to trigger a duty of care for me, might suggest an employment relationship, and they also didn't want to get involved because they didn't want to trigger a public liability issue with the passenger. So they didn't want to have anything to do with it. So just because you have digital means to pursue justice, it doesn't mean it will happen if the incentives are not there. It's a heavily regulated industry, so it often works the other way. So we know that when Uber lost their license in London, the National Police Chiefs Council lobbied for the restoration of the license. You think, now, why did the police want Uber to have a license? Is it public order? Oh, it must be public order. So when the clubs all get out at 3 in the morning, we disperse people home? No, not a bit of it. It's because they have become such a great source of intelligence. You know, so the honeypot is there, we'll dip into it without warrants. It's a heavily regulated industry. The drivers are heavily regulated. I always think it's funny that in the square mile in London, in the city, in the financial district, if you behave illegally as a banker and you rob and plunder the world, they make you a knighthood and put you in the House of Lords. They'll reward you. But if we don't do our job as private hire drivers, and even though it's a public license, we are sanctioned with criminal sanction. It's one of the few licensing areas that if you don't do it right, you apply for hire, you do anything wrong that way, it is a criminal offence. So what did we do about it? We took the action. We took the action in employment terms, but we've also been taking a lot of action on the data protection front. And I'd like to think that these rights, in a way, are precarious rights for precarious workers, but we'll grab onto anything. Because our ambition is, number one, portability. So if we can port the data, set up our own data trust, that is absolutely dynamite organising. And data is a central object of our trade union. Am I okay on time? 3 minutes, okay. I always go over time and get in trouble. But personal data is a organising principle of our trade union. A funny story, when we went to set up our trade union, we went to the certification officer for recognition as a trade union. You have this funny cat and mouse thing where you have to operate as a trade union before they'll recognise you as a trade union. You can't go to them with a plan to be a trade union. You have to show that you're acting as a trade union. And so that involves the regulation of relations with the employer. What do we have there? Nothing, because Uber won't answer our phone calls. If they're a big platform, they don't need to. What kind of collective action are you taking? We said, well, we're suing them. I said, no, litigation isn't collective action. What collective action are you doing? I said, we're seeking our data to set up a data trust. They said, bingo, correct answer. Here's your certification as a trade union. And so we always put data at the centre of our organising effort because we think it's a digital platform. We have to answer it by digital means. We want the data so we understand how people are earning. So 4 simple questions: how much did I earn? How was my time utilised? What was my working time like? And what is the quality and quantity of work that I've been offered over time? We've also been pushing for this access for some time. That access rights are being suppressed. I can get into the cases. We've got a case last week before the Court of Appeal in Amsterdam. But we've also been challenging on Article 22, automated decision making. This has become more important recently because of unfair dismissals. As Uber has fought for its license in London and many other cities, they are quick to deactivate, police their platform in a very aggressive way. Except that they don't really have the manpower inside Uber to do that properly. They want to do it through automated means because they don't want to hire a lot of people to, police us. No. So they want to have an automated means of flagging drivers based on suspicion and kick you out. In fact, the new driver contract says you can be suspended on the basis of a suspicion. The investigation can go on without your knowledge. The information will not be shared with you, and then you can be terminated. That contract, I'm happy to share with you that those are the clauses related to termination. And so we're fighting for, under Article 22, that's protections from unfair dismissal, for automated decision-making related to work allocation, profiling that goes into that. And then more increasingly, we see a lot of surveillance in terms of facial recognition, real-time identification of workers, and again, the shoehorning of that system in order to protect their license with some really bad results. So I'll give you an idea. There are 100,000 drivers registered, licensed in London. At the best of times, maybe 60, 70 are active, and we know that fell to about 40 during the pandemic. In the year after Uber had their license restored by the magistrates court with a condition of real-time identification, the number of referrals to the regulator of deactivations they had done exploded from about 400 2 years prior to 10,600 the year after. And this is all our casework. Finally, to say, in terms of building strength and power, sometimes there's, we grab victory from the jaws of defeat rather than the other way around. you know, we're able to appeal cases, and you know, if worse comes to worse, if we, you know, we'll win these licensing appeal cases where a license has been suspended by Transport for London on the basis of allegations of alleged fraudulent activity from the app. We'll win those cases generally one of two ways. Either we'll get the data and we say, the data doesn't say what they said he did or she did, so that's garbage. Or they won't give us the data and we'll say to the judge, well, we've asked for the data, they didn't give it to us, he can't defend himself or herself, give him the license back. And so we win that way. I'll stop for now and we'll take more questions. Thank you.
Timing. Thanks so much. I would like to directly open the floor to the audience. Is someone having the micro? Yeah. Yeah, maybe we start in the middle? Yeah, you were the first one. Yeah, first there.
Thank you. I live in London. I don't use Uber. I'd rather pay my cash to a cab driver. I don't want my bank details going to a third party outside of the UK, going to America. But anyway, do you know how many trackers are in the Uber app? So I'm just telling anybody who's got an Uber app. It's got 4 trackers, Facebook Flipper, Google Crashlytics, Google Firebase Analytics, as well as Uber Analytics. This is in the Uber app. I'm not sure people know this if they use Uber. It's also got 34 permissions, which include, if you haven't taken the permissions off, you read contacts, read phone status and identity. I'm not going to read them all. There are 34 permissions in that Uber app. So people who are using Uber app, if they're not aware, switch off the permissions that are not necessary to make the app work.
Thank you. Ina was first, I think.
Okay, thank you very much, panelists, for your insights. I have a question actually for Dr. Pieri. The question is sometimes asked, for whom is the city smart? Was this one of the elements that came up in your discussions with citizens as well?
I said it very briefly. It did. But I said it very briefly. It was funded by the Cities Coalition for Digital Rights. The whole smart cities language was not the language that we used. We did talk about, in very simple terms, and as I said, I mean, trying to visualize it in the physical space, about the digitalization strategy and processes within cities. We didn't go into that smart cities language, but people felt, I mean, it came across without calling it that way, exactly through all the conversation around vulnerability, which was really interesting because it wasn't like a clear cut. They didn't see themselves as being, you know, vulnerable, although of course they understood they had much less power. They could see the power asymmetries, but they actually saw themselves as possibly being, if enabled, able to take a much more like empowering role. So I think the whole language and the whole discourse and images around the smart cities concept has been like advocating for so long, I think is actually possibly time to be also questioned. And we didn't use it because the coalition as well was not using that language.
I just want to make a quick comment on the smart city thing. In 2018, the Mayor of London decided that Uber drivers, private hire drivers, should no longer have the congestion charge exemption, so we'd have to pay the congestion charge going forward. And we thought maybe Uber would back us, and they were on the other side. They say, yeah, make him pay it, make him pay it. And it's kind of counterintuitive, but I guess if you're an operator like Uber and you're thinking about cities, you're thinking about congestion, how do we deal with this? There's only two answers here. It's capacity constraints or some kind of smart pricing, road pricing. And so they're smart enough to say, yeah, let's go for the road pricing. And when the independent impact analysis was done, they predicted that networks like Uber would actually pick up market share, and for two reasons. One, because they could optimize better than their non-digital competitors, but two, they could push a greater chunk of that cost onto the labor than others because of their dominance over labor. And that is what's happened. And so, you know, we have this problem now with regulators, or, you know, we say to the Department for Transport, we need capacity limits here. And they're like, oh no, we need smart, you know, that's dynamic pricing and that's too crude, we need road pricing. But, you know, the road pricing, we can see clearly, hurts poorer people. And so, yeah, smart cities for whom?
Yeah, so first of all, I wanted to congratulate because this topic is so important. So thank you for raising a bit the attention in the data protection discourse. We managed this year to have the opening panel on this topic. We launched this observatory for vulnerable people in data protection. So I'm using this part to advertise. Caterina and Alessandra are in this. So I want to talk to you all. But just two questions. First of all, I wanted to ask, what do you mean by equality law? It's anti-discrimination law or national law? And second question, more general. I think you all are from many fields, but not data protection law. What is your perception of data protection? Because the title of the event was Privacy as a Privilege. I wanted to ask, do you see data protection, looking at vulnerable people, is an enemy or is an ally? Because we don't have a clear narrative. We are starting now, but still, we want to learn. Thank you.
I'll quickly reply to the equality law question. I mean equality law and non-discrimination legislation mainly on a European level, so and national legislation. So is that clear? Okay. So some member states provide for more protected criteria than others, and it's mainly in the European directives. And regarding whether it is an asset or not, whether it really helps, it can be a tool. That was what I was trying to say, if we use it in combination with other law. But as James also mentioned, which is extremely relevant, litigation is like the last option, and it's at the moment not sufficiently enforcing the most vulnerable persons. So that's why, amongst others, education is of critical importance for us.
But if I can also answer, actually, and maybe also mentioning something that I heard from James, actually, from the panel before. Two things. It was incredible, but a lot of people, compared to many other EU law regulations, were very much aware of GDPR and the data protection. I think there's been a really good comms done on that one. I think the EU Commission has managed to really get the information about the existence of the regulation and what it means for people, the law, like really to a lot of people that are much less, they're not experts in the topic and they might not discuss EU regulations every day. So it was quite surprising to see there was quite a high level of awareness. I think the interesting thing about the data protection and GDPR specifically is this idea of that is very much based on individuals. And we're talking about, especially when it comes to vulnerable subjects, we're talking about population-based level decisions that are made through algorithmic decision-making, automated decision-making. So therefore, I think maybe there is a bit of a mismatch there between the individual protection of rights and the collective right to exercise that, which is not what the law is being made for.
Yeah, I mean, for sex workers, some sex workers are aware of data protection laws like national law, in the European context. But as I said, it's always the sex workers whose first language is usually English, and they are they have citizenship in one of the European countries. So these privileges of course enables them to use these protections, and it is useful for them. But it also leaves out the most vulnerable, most marginalized group within sex workers. So yeah, I mean, it should be made more accessible, basically.
I would say very briefly that laws like the GDPR are very much framed around individual rights rather than worker rights or collective rights. And so we're always fighting against this presumption that the law is there to protect individuals, individual consumers, rather than workers. And you know, it was brought home to me when we sat in the Court of Appeal in Amsterdam last week. One of the drivers in our WhatsApp group said he was looking at all these arguments against us, saying that I thought GDPR was to protect innocent people, not to be used as a shield by companies like Uber. And you know, possession is 9/10 of the law. You know, the presumption is they control the data. They control the data, even though they insist that the contract, that the drivers are self-employed and the contract for the work is between the driver and the passenger. But they control the data. We can't access it, and the presumption of privacy is that they get to protect it and they get to decide. And so, for me, these rights are precarious rights for precarious workers. But you know, we'll take them and we'll work with them. But they need to be strengthened. And there is some work in the EU draft directive and platform work to start to address this. But we need to go much further forward. And finally, I would say a really good example of this is the right to portability. You know, that was framed around competition law and trying to stop a lock-in. But then when we try to use it as workers, they're like, what are you doing? You know, and I mean, we have that right, but the argument back is that's not what that right's for. That's what we kept hearing. We kept hearing, this is an abuse of rights, what you're doing, setting up a data trust or seeking to port. Of course it isn't, but you know, the burden on us is to prove it isn't.
Almost the last one in the back. Lady with white jacket was the next one, I think.
Thank you. Yeah, I think it's very linked to what was said before and now, actually. So there was the French Data Protection Authority published some data about who makes a complaint in France. And it was interesting to see, and maybe probably not surprising, that, of course, most people making a complaint about the infringement of data protection law were people in urban areas, of course, Paris, of course, people with a certain educational level, male, mostly, and probably also other demographics. And then, of course, it's not surprising, right? But then it also made me think about the fact that there are a lot of rights that exist on the paper, and they are very difficult to exercise. Really, we're talking about accessibility. We're talking about user-friendliness of rights somehow, which reflects, I would say, what happens also in the non-digital world. So I don't know if you've ever asked for unemployment benefits in France, but it's a nightmare. Okay, so you need to have a lot of time, you need to have digital skills, and you need to be very determined, you need to understand the language, it was mentioned before, and probably also many other things. So something was mentioned already, but I was wondering, do you have very specific ideas or proposals that we should implement in order to make those rights more easily accessible and exercisable by, of course, more vulnerable communities, but also all sorts of communities?
I don't want to dominate, but I've got three suggestions of areas of where rights can be strengthened. One is portability rights. And they shouldn't have to fight for them. They should be baked into the EU directive platform work. It's not in there at all. And I can't see how you build power without having access to that data, so you understand what the working conditions have been. Explainability is a huge one for me, particularly around automated decision-making, particularly around work allocation, dismissals. There's a lot of work being done by the ICO in the UK with the Turing Institute on what constitutes proper explainability and what doesn't. I'll come back to that in a second. And then on automated decision-making, you know, the presumption, there's to be clear, you know, it's almost as we have to prove that the automated decision-making is happening, that we're subjected to it before it's exposed to us. And that you know, there's a game of hide the ball going on here, and that we don't have time for that. But on the explainability issue, I'll give you two mad examples. One is we wrote a report. If you go to Worker Info Exchange, managed by bots, we've done a report on this. But we were looking at the privacy policies of some of these gig platforms. And we complimented Deliveroo, because Deliveroo said, oh, all the work allocation is completely automated. We couldn't possibly do that by human means. We thought, oh, that's great. So you've been clear and honest with us, because Just Eat said they do all their work allocation of work without any automated means, which is nonsense, obviously. And then as soon as we said that, they took it all out, because I guess they were afraid we might start triggering Article 22 or something. They took it all out. And then Free Now, your neighbours in Germany, they had this thing, in terms of, this is about the topic of explainability for workers. It said that in work allocation, they have this random forest algorithm that detects patterns of fraudulent behavior, creates a risk probability score, fraud probability score, and then uses that profile in matching and work allocation. And so we said, yeah, that's all a bit mad. Tell us a bit more about that. And you know what they did? Overnight, they reissued their entire privacy policy and took it all out. So, like, were you never doing it and you were just making it up, or were you always doing it, or have you stopped doing it? Like, what is this? And this is terrible in terms of explainability. And we're going to get nowhere in invoking rights if we don't understand what's going on as isn't explained to us properly. A lot of work needs to be done on explainability.
Can I add? Sorry. No worries. I wanted to add a little bit. I completely agree with the importance of explanation, meaningful explanation, but I wanted to add the role of education. As I already said, I think it's very important that we invest a lot in proper education, accessible education, and start by mapping the specific needs of all vulnerable groups. We haven't paid attention to disability rights, but only talking about disability rights and in the context of accessible education and the impact of digitization deserves a lot of more attention in the current debate. And I also wanted to stress, I maybe did not do that properly, but as a public institution, we treat individual cases. We provide free legal advice and assistance to individuals. So if you install sufficient supervisory authorities with a lot of legal means that are accessible to the most vulnerable and that do cooperate. For example, we cooperate a lot with trade unions and other actors. Even those who have difficulties with completely understanding their rights might be helped in a more practical way than all these theoretical rights on paper.
Yeah. Someone else?
Hi, thank you very much for your presentation, for different but great. I really appreciate the panel. My question is more related to the generic interrelationship between data protection and discrimination, so probably the representative of UNIA can reply to this question. How do you cooperate also with data protection authorities? Is something common? It's something that is coming? My question is for that, because I've been to a conference last week and I was more with non-discrimination people, let's say, and I still see a sort of skepticism towards data protection law, especially for the framework created to collect sensitive information and special categories of data. Thank you very much.
Yeah, the skepticism is definitely there, and the debate on whether to use or not to use sensitive information and blindness by fairness, etc., is a very critical debate where we do not have a solid view on. But about the cooperation with data protection authorities, I can tell you that it varies from European countries. So some of our colleagues have excellent cooperation with the data protection authorities in the countries. It depends also on their independence. So, for example, German commission might have a better reputation than other commissions, and I think that need to be improved. And also with the future AI regulator, there might be some room for institutionalizing a permanent forum of dialogue of all actors concerned with digitization. I don't know if that replied. Okay.
Okay, still a question with the mouse mask? Yeah.
Thank you. So my question is in relation to, as you're saying, that rights are more oriented towards the individual. So I wanted to know, do you feel that maybe a collective dimension to privacy and data protection can actually be useful for vulnerable communities, groups, and societies. Thank you.
If I can start, just something more generally, like not me personally, but I think I mean, at least the majority of the people on this panel, I don't want to speak for everybody, are not expert in data protection law, etc. But one thing that we always say when it comes to democracy is that, for instance, a collective, I mean, democratizing, bringing democracy principles to some of the conversation, for instance, around digitalization processes, will include that understanding of moving the conversation from the individual to the collective. For us, would be like very much one of the real meaning beyond simple, like, you know, citizens' engagement or participation. On a deeper level, one of the issues of adopting a democratic or democracy lens to look into questions of digitalization is start thinking about rights in a positive way, and as affirmative rights, for instance, but is also very much about moving from the individual to the collective. That would be, like, in general, like I would say, an important principles looking from the democracy lens on the topic. Can't speak about the law specifically.
Someone else on this question? Okay. No. We have 1 more minute, I think. One last short question.
Hi, Midas Nouwens from Aarhus University. I have perhaps a very pragmatic question for James, but also for the rest of the panel, if you have any experience with this. You mentioned education as one of the things that we need to do to help people exercise their rights more. So I try to do this in my classes at the university, where I have a big undergrad class, and I make everybody in the semester submit an access request, which, to be honest, out of the 200 students that I get, perhaps 5 of them get it within time with actual useful information. So I'm definitely on board with, I think education should be better, but so far, poor results. Then recently I've been involved in a project where I'm trying to represent children accessing their data that's been collected as they're playing games on their mobile phone. And here I run into a whole other problem. So my question, I guess, for James is, and everybody else, how do you do that when you're trying to represent somebody else exercising their rights? Because the problems I run into is, oh, but you don't have the right to do this for this other person. You need to contact us through their particular account. So I need to then log into their email address and all these other kind of procedural hoops that I have to jump through, right? So I feel like both of these things, either educating people to try and do it themselves gets bad results, or trying to represent vulnerable people, in this case children, also not very successful. For James, it seems to have worked a bit. So what's the secret?
I'm not sure it has. I mean, you know, this is the problem with the presumption of the controller being in control and the presumption of the individual rights. Because when we do, you know, so we've set up a secure process with Onfido and Scrive. So we set up, like, we get the legal mandate signed, and then we do the ID check through Onfido, and we present this certified, authenticated, ID'd request, and which is what they asked us to do, and now they don't want to accept that either. So this is a perennial problem. But what we have to recognise, what we're dealing with is active suppression. So you know what some of these platforms have been doing is then going back directly to the data subject and say, did you ask for this? What did you want exactly? You know, asking sort of vague questions like this. But it's part of suppression, because that can be quite intimidating. If you've gone to your trade union or a civil society organisation to make the request, and then you're approached directly by the data controller, that's intimidating, and that's suppression. But the EDPB needs to be clearer about some of this stuff, because they're telling, in the EDPB guidance, which we challenge, in the last consultation, talked about a layered approach. It's okay for a controller to take a layered approach to releasing that data to you. What the hell is a layered approach? I mean, it basically allows them to curate, decide what they'll give you in the first round, if there's a first round, the second, the third round, fourth round. And so what we see is that you know, we're getting smattering of what they want us to see, but not the full data. I'll give you a practical example where this was a huge issue. There was a driver accused of fraudulent activity. I won't get into the details. But if you look in the portal with Uber, the driver portal, it gives you some description of the type of data that they would give you. And it says detailed device data, detailed device event data. So you download this file, or they send it to you after a month. But we know now that it's stripped of the event name, the event type, and the user action that created the event, as well as the transformation of the device or the app, as a result of the event. So what is it they've sent you that's event data? It's chaff. And this is really important for people who are trying to prove that they didn't commit fraudulent activity, like share their account, for example. But it's a way of bamboozling people. But unless you know, this is why organizations like ours have got involved. Because if you ask yourself individually and you don't know all this, you're just going to get the runaround, or you're going to get a half disclosure.
I think we ran out of time. Thanks so much, everyone, for being here.
Thank you.